Can we get crime scene up here, please?
I am going to get the best of you. You're a bad person.
Violations of Kearney's civil rights and conspiracy. The claims against the Massachusetts State Police would be...
Wouldn't it be appropriate to bring them in for the civil rights violation? Of course, it's been a long time now. We've been following the Karen Reed cases, the Aidan Turtle Boy Kearney cases, and others. What happens when prosecutors in Massachusetts don't necessarily follow the rules? Yeah, some prosecutors have done some very questionable things in the Karen Reed case, the Aidan Kearney case, the Brian Walsh case. I guess I could go on. I'm attorney Andrew Myers. This is About the Law. Joining me is California attorney Yolie Medina. How are you, Yolie?
I'm fine. How are you?
I'm good. You still following these cases even from California?
Yeah.
Okay.
I'm not following any California cases except for one, but...
Anything that's worth doing an episode on?
Probably. I'll find out next week and we'll see.
Okay. That sounds good because we spend an awful lot of time on the Massachusetts cases, although there's a lot of turmoil in Massachusetts.
Yes.
Speaking of which, there's an article that came out just as we are recording this episode in Massachusetts. This is from the Massachusetts Lawyers Weekly. This is the publication that all attorneys serious about their business read and follow. It's a weekly, but it also has electronic versions that come out on a daily basis. This article talks about prosecutors facing suspension in wrongful conviction cases. So this is dated September 26, 2025. As I said, Massachusetts Lawyers Weekly. A Board of Bar Overseers hearing committee is recommending that 2 former Plymouth County prosecutors be suspended, one for 2 years and the other for a year and a day, for their actions that led to a Brockton High School senior spending 17 years in prison after being wrongfully convicted for setting a house fire that killed her parents.
The hearing committee found that the misconduct of John E. Bradley Jr. and Karen H. O'Sullivan fell into 2 broad categories.
The first category that led to their recommended suspension: first, they failed to disclose crucial evidence that suggested another suspect may have been a motive for setting the fire. That suspect was defendant Frances Choi's 16-year-old nephew, her father's grandson from a previous marriage, who had come to live with their family, Kenneth Choi. Now, wait a minute. Before you tell us the second grounds, does this sound familiar? Failing to disclose crucial evidence that suggested another suspect may have had a motive? Does that sound familiar?
Yeah. It sounds familiar, yeah. In a lot of cases, especially one comes to mind. But in any event, second, Bradley and O'Sullivan had mocked both Frances and Kenneth in emails that referenced their Asian heritage, including one that likened Kenneth to the character, and you can read that there. I'm not going to read it. From the 1984 film 16 Candles. Even though he bore little resemblance to the character, the hearing committee found. And if you haven't seen 16 Candles, you should see it, and you'll see the character that they refer to. And it's a pretty disparaging, likening Kenneth to that character. It could be funny, but in light of this incident, it's not funny.
You know, Massachusetts has a reputation that I don't think is well deserved, but it has a reputation of being an enlightened, liberal, open state, and this second charge certainly points out that that's not necessarily true in all cases. The 2-member majority of the hearing committee, attorneys Payel Salzberg and Melina McTighe Garland, said they were, quote, struck by how seriously the respondents' misconduct undermined the integrity and reputation of prosecutors in this Commonwealth. So they kind of broadened it out. Not us. This is the people at the hearing committee of the BBO. pointed out that they were struck by how seriously the respondents' misconduct, respondents is another word for prosecutors' misconduct, undermined the integrity and reputation of prosecutors in this Commonwealth.
So it says, we cannot minimize the harm to the integrity of our legal system and the administration of justice when the motivations and biases of prosecutors become news, they wrote. When the prosecutor's actions give even the impression of bias, when the defendants are not treated with dignity or respect, when prosecutors do not ensure that they are playing by the rules and disclosing exculpatory evidence is required, the public is left to question whether the promise of a fair trial has been fulfilled.
Salzberg and Garland continued that Bradley and O'Sullivan's conduct was unacceptable. So let's go back up to the top here. This is Frances Choi pictured during her 2003 arraignment with her attorney, Joseph Krowski of Brockton. Spent 17 years in prison after being wrongfully convicted for setting a house fire that killed her parents. So what a amazing story. She spent all those years in jail, and it turned out that the prosecutors failed to disclose crucial evidence that suggested that another suspect may have had motive for setting the fire. You know.
Right. She was convicted by a jury, right?
Yes.
Yeah.
So, I mean, it's just amazing that such a thing happened. But speaking of misconduct by prosecutors, we've just read and reviewed and digested and are now waiting for a hearing on Aidan Kearney's attorney's motion to dismiss and also the affidavit. And hidden in the affidavit, which didn't come to the surface right away, is some just amazing stuff. Speaking of misconduct, one of the things that was hidden in the affidavit that Mark Bederow had filed in the mega affidavit, or I should say the mega motion, was a communication by Kate Peters. Kate Peters was a Turtle Boy hater. She had worked for him, and then they stopped working together, and she just had an animus of hatred towards him. And she was bringing together a lot of evidence that the prosecutors, it is said, relied on heavily in their prosecution of Aidan Kearney. And this was hidden in some of the links in the affidavit, and it just this is Kate Peters leaving a message for Aidan Kearney.
Hey, faggot, it's Kate. Kate Peter. Crusty panties, how you call it. I just wanted to let you know, every time you get a block number, it's not Lindsay or LG or anyone else. It's me. And I just want to let you know that when you go back to jail, I had absolutely everything to fucking do with it because you're a dumb right? And every time that you victimize a female, I'm going to be right there pushing back. I just want you to know that. Play this on your fucking live show. I am going to get the best of you. You're a bad person, and everybody's going to see it. Have a nice day. By the way, Karen Reed wants nothing to do with you. Go f*** yourself. I meant it. it.
Nice talk.
I don't know why people would leave voicemails like that. I don't know.
I don't know why the Commonwealth of Massachusetts, by way of its Norfolk County District Attorney, would rely on someone who leaves voicemails like that as their, if not prime investigator, a key person who was generating information that was fed to the district attorney through Lieutenant Detective Tully and others, in order to bring charges against Kearney. I mean, it's just unbelievable. If that voicemail isn't an indication of extreme bias and a motive to, do whatever they can to hurt somebody, I don't know what is. I don't know what I've seen ever. And again, this was hidden in some of the links in the affidavit, which we're going to take another look at as to why this is so important. But one of the things that Kate Peters did was she teed up the police to arrest Mr. Kearney on the day that he was initially arrested back in September of 2023 at the bus stop of his kids. He goes to drop his kids off at the bus stop. I mean, that's what parents do. And she watched and figured out, here's the bus stop, here's the time, here's the place, here's the days. And so the next video we're going to listen to was also hidden in the links of that affidavit. And this is the Massachusetts State Police driving around and gearing up to arrest Mr. Kearney at that bus stop.
Yeah, we got a bus, but it's a little early, right?
Supposed to be around 8:30, but Kevin, if you want to try to take a drive-by past that bus.
Oh, so they got there beforehand, before Mr. Kearney's bus, and there was another bus there. Too bad. They've got to sit and wait. I'm sure they went to Dunkin' Donuts and got their coffee.
Yep, I'm right in front of the bus. I don't see two kids getting on the bus at that street.
We'll take a look. And again, without really hearing you guys too good.
People that listen to scanners are used to this low quality video. I mean, I don't think they've gone totally digital. You can, police and fire and other emergency services have, to a large extent, gone digital, but I don't think this is it.
Kevin, can you go again? Two kids on the bus or getting off the bus? There are two older kids that are getting on the bus. I'm sure there's another one coming through. Received. Sir, from KP, it was the same thing yesterday.
The information was from KP. I wonder who KP is. Is it a coincidence that those are the initials of Kate Peters? So she's the one that fed him the information to do this nab at the bus stop.
Older kids got on around the same time as now, but it was definitely 8:30.
That's what KP said.
Received. It should be bus 30. Standing on a comms check. Kevin. R9, sir. I'll let you go, Johnny.
We got him. That means they see him.
R9. What's the R9? Cat.
They're sitting and waiting. They're sitting and waiting. I wonder how many cruisers they had. I mean, good grief. How many cruisers does it take to arrest one peaceful parent at a bus stop?
R9. Ryan.
R9.
Crime scene. R9. Received. R9 on my end. And we'll just stand by for word. To all units on that. Disregard.
Wrong bus.
There's a school van, a gray school van that just pulled in there now. Someone wants to drive by. Pulled into that residence. Negative into the circle across the street. Okay, received.
Didn't Kate tell them that it was a gray van?
Standing by for the yellow target to go by.
Oh.
Received. I just had a Lexus pass me. I'm just confirming it's not him. That was not our target.
He's a target. Taking his kids to the school bus stop, doing the right thing, and now he's a target by the Massachusetts State Police.
All units, bus 33, coming off of Wood onto Boulder.
Making a stop on Boulder.
If we can have all units in place at the predetermined location.
So apparently somebody was, one of the cruisers was back where the bus was going to be making a turn, and he was calling forward, we got the bus is on the way. Very well coordinated. I mean,
Yeah. And it says, I like how it says special event ops. like a special operation, like some kind of a, task force getting a drug dealer, or something. I don't know, like something really sinister.
It would seem to me there'd be a lot easier way to arrest somebody. I mean, why did they have to arrest him in the first place? But if they're going to arrest him, they have to go through Kate Peters to surreptitiously determine the time and place that a bus is going to be picking up his kids? Really?
Like she's some special informant that is working undercover, and they're going to, I don't know, maybe I've been watching too much TV.
No, you've been watching this, because in a minute when we get done with this, we're going to take a look at the affidavit and why this is so relevant to this case. It's extremely relevant. I'm not just playing it because I think it's, something, Car 54, where are you-ish. Gosh, do I show my age sometimes. It's something that's relevant to the affidavit.
Back for work.
So are you close to the Mason? I'm stepping off from that spot. Towards Mason.
Everyone else, please stand by until I give word.
That's the commander.
We'll follow behind you in a minute.
All units, once transport moves out, we can pull into the driveway, and we can, the residence is clear, no occupants, deactivate BWC. Deactivate. Can we get crime scene up here, please?
Crime scene. You know what's interesting about that? Crime scene. They didn't even have crime scene at outside of Brian Albert's house that day that John O'Keefe was found on the front lawn. They just had solo cups and a leaf blower. Crime scene at a kid's bus stop? Really?
Route 6.
Okay, that's it. That's
Wow.
it. Kind of anticlimactic, but I mean,
Well, what?
just go ahead.
Geez, it's just crazy. Crazy.
That they went to that extent to get Mr. Kearney at the bus stop. It just, to me, seems just a tad crazy. Here is the affidavit that was signed by Mark Bederow that accompanied the mega motion to dismiss the Aidan Kearney case. And the final pages indicate, with respect to the motion to dismiss, the indictments due to the prosecution's impairment of the integrity of the grand jury proceeding, the defense at a minimum has raised material questions of fact regarding, and the ones that are pertinent here, what evidence did Ms. Peter provide to the Commonwealth? To whom did she provide it? Who reviewed it? And did anyone vet its authenticity or reliability? And if so, when? Were they just, taking what she gave them and throwing it together? I mean, did anybody take a look? Did anybody call her in and ask her questions and sit her down?
Yeah, like they do with confidential informants. That's what they do.
Exactly.
Yeah.
Did Mr. Mello, Detective Lieutenant Tully, any other agents of the Commonwealth review, preserve, disclose, or delete evidence provided by Ms. Peter? Did Ms. Peter delete or destroy evidence? Now, this could go towards the issue we covered in a previous episode with respect to his episodes, which go on for hours, but they edited them down to very short clips and gave them different titles to give intent to Mr. Kearney. So this could go to this, but in my reading of this, no, this goes to what Ms. Peter provided to them. And, did they delete any? Did they monkey around with it? What did they do? And finally, whether
So it's like the chain of custody of what she was giving them. In other words, yeah, like what if it was electronic evidence? What was the chain of custody? Like who had what and who did what to what? And it just seems like whatever she gives them, they're using, and that's it.
Yeah. And then whether any or all of the answers to the above material facts establishes that the Commonwealth misled the grand jury by intentionally or recklessly presenting false or misleading evidence, or in any other manner that impaired the integrity of the grand jury's proceeding for purposes of securing Kearney's indictment. So this material that we've been taking a look at here, and I'm just scrolling to show you that that's the end of the affidavit that was signed by Mr. Bederow, and here's the top of it, affidavit in support of motion. This is the affidavit in support of the mega motion, and it is 88 pages long, and we covered some of it in a previous episode. I think if our viewers want us to, because it is so lengthy and goes into such great detail, we can, in fact, take a look at it in the future with respect to other issues. But, that just goes to show that a lot was going on behind the scenes. And I wonder if the people in the Norfolk County District Attorney's Office, which came first, the chicken or the egg? Did they want to do this prosecution and then along came Kate Peters, or did Kate Peters generate all of this and give it to them and then they picked up on it? I wish I knew that.
People get attached to negativity toward a person, and then
But that case seems to be falling apart. The special prosecutor, Robert Cosgrove, was sued by Gaetano, and so now he has to back out. The court this week, as we're doing this episode, dropped an order to the Norfolk County DA's office that they've got to come up with somebody within the next 30 days. They've got to come up with a new prosecutor to step into the case in the next 30 days. This motion has been set down for arguments. That's how it works in Massachusetts, and I'm sure in your jurisdiction too. A motion is filed, and then the court sets a date for arguments. The strange thing about the criminal procedure in Massachusetts is that the prosecutors have until the day before the hearing, December 5th, to file their opposition. So that does not give Bederow much time for a reply brief. I mean, I've had stuff given to me the day of a hearing, which I never liked.
Oh my gosh. Well, ex parte hearings in California are like that. That would be that. Those are the rules for the ex parte hearing. You get any opposition to the ex parte like a day before or at the hearing. So, but one of the good things, at least, well, in my opinion, is that you can argue in front of the judge, the reply to the opposition, because if they file it the day before, and if oral argument is your specialty in terms of putting something in writing and boring the judge to death, if oral argument is your thing, then you can go in and really give a powerful oral argument in opposition to their opposition, or in reply to their opposition. So it could be favorable, but still that doesn't give them much time to digest everything and, put it into some form of comprehension,
So the real question now is, who will the Commonwealth, having been ordered to do so in the next 30 days, who will the Commonwealth bring up to jump into this case? There have already been two special prosecutors, Mello, Cosgrove. I mean, who would want to do it? I mean, the district attorney's office has all these attorneys who Vanity Fair correctly said that none of the top attorneys in the Norfolk County District Attorney's Office wanted to try the Karen Reed prosecution. Who in the world, I'll say, would want to step into this case? I mean, are they going to... How many special prosecutors does that office have the money for? I mean,
it's taxpayers' money, and, special prosecutions. What are they going to do now? Bring a federal person? I mean, can they do that? Can they bring a federal prosecutor?
Why would a federal person want to have anything to do with the Norfolk County District Attorney? No, I don't think the Justice Department would want anything to do with that. I don't think they would.
They'll just get a retired judge.
I'm only licensed in Massachusetts and New Hampshire, but both states have mandatory retirement for judges at the age of 70. Now, a lot of them that still have their morals together, and there are many of them like that. I've known some of them, and mediated because they get off the bench, and either they get called into cases on special assignment, or they mediate. And I like to mediate or arbitrate before former judges because they've seen a lot more than most practitioners. But I guess my point really is, they could reach out into the venue of retired judges. They could get a private practitioner, which is what Hank Brennan was. He is a defense attorney in downtown Boston, and he stepped in. But what attorney would really want this kind of a thing? I'm not looking for work. I have more than enough. I've spent this week my quarterly review of all my cases, and my head is exploding. I hope my clients aren't listening. But I think, I'm just trying to think what kind of a practitioner would want this kind of a case.
Somebody who wants money, probably.
This case reminds me of Pigpen. You know the Charlie Brown cartoons, the video, and Pigpen walks in and he's trailing all of this dirt behind him. That's this case. That's what this case reminds me of, and I
don't know. At this point, I'd rather be Snoopy than be a special prosecutor for somebody in Massachusetts on a case.
And it would seem to me that the prosecutor's got to get moving, because if the arguments are going to be on December 5th, we're going into October now, and that only gives you 2 months to do the briefing, the research. You probably want to talk to people because the affidavit raised some facts, and you probably want to do some research and talk to people. And,
so who's going to do that? See, that's the thing. The prosecutor's office has investigators and things like that. So if they assign a special prosecutor, is the special prosecutor going to be working with the DA's investigators and all of that, or do they have their own separate?
Well, that's a good question. That is a really good question. I mean, wouldn't you think that all that the Norfolk County District Attorney's Office has been through in the 2 Karen Reed trials, in which she was acquitted on all the major charges, and only found guilty on drunk driving, which I'm not saying it's a good thing, but I mean, all of that fuss and bustle and money and, $1.5 million for a drunk driving, do you really think that a district attorney's office ought to, be spending this kind of time and effort and money? I mean, the retrial's over. It's in the rear view mirror. There's movies being made. There's books being written. There are podcasts continuing to go. And I asked you this in the last episode. We started collaborating roughly 2.5 years ago, and we started talking about the Karen Reed roughly at that time. And I asked you, did you have any concept that these cases would still be going, that we would still be talking about these cases this long after? And your answer was no, of course not.
Yeah, consciously no, but maybe unconsciously or subconsciously, maybe I thought there was something not right with these cases if they would continue on, But consciously no, I thought this was just a phase, this is the trial of the century for this year or this 10 years or something like that. Like these were the biggest trials, Kohberger and Karen Reed, but they continue on.
They continue on. They have a long tail. The thing about district attorneys, what I usually think of outside the district court purview, or even in the district court, more so up in the superior court level, district attorneys I think of as being sharp, serious, and not that they don't have a personality, but when they walk into a court, they want to have been extremely prepared and done their homework, done their research, gathered the facts, lined up their witnesses, and cutting a really sharp image in that court, not wanting to take on cases that are just fuzzy and have flaws, and witnesses are going to turn around. So my impression of Norfolk County District Attorney is that that's not it. They want to pursue stuff that they know is not really in that image of being a sharp, well put together, tight case where all the Legos are going to fit together into the final product. So
yeah, and now I feel like it's like a gaslighting event. It's no longer a trial. It's what you can make the other person look like in the media. It's no longer what's in the courtroom, what evidence is admissible, what passes the rigor of, evidentiary standards. It's now, everybody's out there, putting out photographs of Karen Reed, and Karen Reed was talking. She didn't remain silent. So everything that she said could have been used against her, and it was, and she still was convicted of a DUI.
Which was a very minor thing compared to, the charges that they brought against her. you had mentioned that Karen Reed spoke, and a lot of us kind of cringed because the standard advice is that you tell your defendant, don't say a word, remain silent, let me do all the talking for you. But she's a very smart woman, and I'm sure that she spoke with her attorneys and everybody agreed on parameters. You'll talk about this and you won't talk about things outside of those parameters. That's A. But I felt that Mr. Brennan was very inartful about the way he used all of that material that Karen Reed had given to 2020 and Dateline and Boston Magazine and Boston 25 TV did a great interview with her. And so it seemed to me that what he did is he took little snippets of it and he played them randomly at random times in the trial, which was kind of out of context. Maybe in his mind he studied it very closely and maybe she said the same words that had just been said by a witness, but it was a really random connection. That
was effective for establishing the DUI because she admitted she was driving and she had drinks. So perhaps and because I do remember the jury asking a question about whether those videos were evidence that he showed. And the answer was yes. They're statements by, the defendant. It can be used against her. And I do remember that question. And that's probably the only reason why she got charged with the DUI, because she herself said she was driving and had drinks.
So different attorneys have different trial strategies. If you sit half a dozen attorneys in a room and give them facts and documents and affidavits and videos, they may come up with 3, 4, 5, maybe even 6 different strategies to try a case. And I felt that the strategy to just kind of play those statements of Karen Reed, randomly sprinkled through the trial, like chocolate on top of your ice cream, I don't think the jury paid any attention to it. I don't think it had any impact on them at all. So, coupled by the fact that I think that Karen Reed was speaking very intelligently within certain parameters, but also that they were so inartfully used with a questionable strategy that it had nothing to do with it. So I cringe, and I hope, and I read an article about this, I cringe to think that defense attorneys now will be faced in every single case that comes to them with their claim. Well, Karen Reed spoke, why can't I? And I'm not talking about going, how many defendants can go on 2020, Dateline, Boston Magazine, and all the rest. Most of the cases aren't, that widely viewed internationally. And we've had people from 80 countries watch us. But still,
I could see people thinking that, but Karen Reed had a confidence, it kind of made me uncomfortable, but it didn't. I mean, it was her choice. She had competent attorneys, and at the end of the day, there wasn't a collision that was proved. They couldn't prove that there was a collision, that she hit him, and that's really the thing. Did she hit him? And what was presented in the court, the blue man guy, I don't see it. I never saw it from the very first time I got into this case because of you. You were telling me the facts and I was listening and I'm like, I don't see it.
I always said to myself, I don't see it. There's something else. There's something. My mind always wants something else, and there was nothing else. It's just that there was
not even from a personal injury standpoint. In other words, if this was a case of a hit and run, let's say, which I guess that's what they're trying to say, I don't know, that there wasn't enough proof. I mean, not even...
I don't even think it was a hit and run. I mean, the ARC experts, one of the ARC experts said that the vehicle did not hit John O'Keefe, and the other one said John O'Keefe was not hit by a vehicle, as did Dr. Marie Russell, as did others. And then, as you pointed out, the Blue Man Group experts, Aperture, one of them lied on his resume, and it does matter. People have said down in the comments it doesn't matter. It does matter because when you're a witness, your credibility is always an issue. Credibility is always an issue with every witnesses, especially in a trial where there are multiple, I forget, 65, 70 different witnesses. The jury's just looking for a way to weed out some of the chaff and get to the point. And that's what happened when one of the Aperture witnesses, Burgess, phonied up on his resume and said he'd been working on his bachelor's degree since 2008. And then the other one kind of randomly, he did the test, 3 times, the Blue Man Group paint test. But my question was, whatever happened to the legal requirement of substantial similarity? He held his arm like this. We don't know how John O'Keefe held his arm that night. So yeah, I agree with you 100%.
The substantial similarity was what he was wearing. He was wearing the exact outfit. Come on.
There was a bill for the hat and the shoes, and I forget what else.
It had nothing to do with it.
No, it had nothing to do with it, but I mean, I don't know. It's just, that's crazy. That's ridiculous. I see the case falling apart.
The Commonwealth is going to try to save face somehow. And they're going to try to make it look like, well, this was just an unfortunate event and the people who were liable or committed these crimes are just going to go free because it's not fair.
I want to ask you a question, and I didn't prep you for this. I'm going to ask you a question on a scale of 1 to 100. What do you think the chances are that Hank Brennan would come into this case as the new special prosecutor?
60%.
Really? Oh, I would have said like 5% because...
No, I would say 60%. And the reason why I say that is because if he was willing to take over the Karen Reed case and do it with a straight face and put on an expert who lied on his CV or resume that he had a bachelor's degree when he didn't, then that tells me that he will do a lot of things for getting paid. Because I would never, ever, I think I could get in trouble in California if I put up an expert who has lied about his credentials and I knew about it. Did Hank Brennan know that this expert, his CV, has said he had a bachelor's degree and he had promoted his CV in other federal courts and other trials? Did Hank Brennan know that this guy did not have a bachelor's degree and the CV was submitted in the expert disclosures? I mean, I would get massive trouble in California. That's how I see it. I would never do that.
I don't know. Did he know? I don't know. He would have had to have known. I would have thought he would have had. Usually you spend time with an expert before you go on trial. You spend a fair amount of time. You sit down with them.
Yeah. If he didn't know, he should have known.
You break bread with these people. You go out for coffee. You have sandwiches shipped into the office or whatever. You spend time with these people going over everything. So I agree with your point that he either did know or should have known. I disagree with your point that there's a 60% chance that he would step into this role. I say there's a 5% chance, if even that, because one, he made his $566,000, cashed the check and ran. What the heck does he want to do with this case? And the other thing is...
There might be a conflict, though.
Well, yeah, the other two had to leave because of conflicts. Both Mello and Cosgrove had to leave due to conflicts, and all Brennan would have to do is get sued, and now he's out. So, so the next attorney that comes in is very likely going to be sued themselves. So, well, think about it. So I don't know. I would give it a very low probability, but you never know.
Look, that's the only criticism I have of Hank Brennan, because, you do a job, you have to defend, you have to prosecute, but prosecuting and getting an expert that is lying about his credentials, that's something else. And so I understand everything else Hank Brennan did, even though whatever, but that one point where he put up that expert, that I don't understand, and I don't know why any prosecutor would ever do that.
Well, despite the fact that they got paid so much more money, more even than Mr. Brennan, I thought that Aperture did a pretty sloppy job. I thought they did a pretty sloppy job on that investigation. It was pretty obvious that they were hired kind of, sort of, in the context of everything at the last minute. and it was I don't think the jury bought it. No, obviously they didn't buy it.
They
So
didn't.
my final thought on this is in our next episode, I would like our commenters to tell us whether they think we should do a follow-up episode on Mickey Steins, the Kentucky sheriff who shot the judge right on TV. But now there's this defense of emotional distress. And then whether we should do that case or Rex Heuermann. That case is coming up. There have been some recent rulings on the suspected, alleged Long Island serial killer. So I would like to ask our viewers which case they would rather have us do. Whoever wins has to have more than 10 comments. And if we get more than 10 comments, we'll do one of those in a very soon upcoming case. So that's my closing thought. Do you have any closing thoughts?
No, other than I'm just drained by such craziness going on in the world and in Massachusetts.
I forgot to do our comments. I forgot to do our comments. So let's do our comments. You want odds or evens?
I'll have the odds.
Okay.
So hook, line, and sinker 145 says, good start, or it says good, start with the Alberts and Higgins and throw the town of Canton in there too. Ridiculous.
That goes to Karen Reed's new defense attorney going into court. Just the other day as we do this episode, attorney Damon Seligson named all the parties he wants to bring in. I forgot to play that video. Should I play it or should we move on?
You could play it since there's a comment about it.
From Ms. Reed's perspective, we have affirmative claims that we intend to bring on her behalf. Those claims stem from the same facts that are at issue in this case. Those claims, Your Honor, are against parties that are not in the litigation at this point, including the Massachusetts State Police, Lieutenant Brian Tully in his personal capacity, Sergeant Yolie Buchanan in his personal capacity, Michael Proctor. Those claims would be in the nature of violations of Kearney's civil rights and conspiracy. The claims against the Massachusetts State Police would be negligent training, supervision, and retention of Massachusetts State Police troopers. We also intend, Your Honor, to bring claims, affirmative claims, against Brian Albert, Nicole Albert, Matthew McCabe, Jennifer McCabe, and Brian Higgins, who were the occupants of 34 Fairview Road in Canton on the night in question. Those claims will be in the nature of civil conspiracy, violation of Kearney's civil rights, and then a claim against the town of Canton through its police department for negligent failure to secure the garage in the Sally Port.
Okay, Damon Seligson, the defense attorney for Karen Reed, indicating 10 new parties they want to bring into that litigation. Let's go back to our commenters. And so that's what Hook, Line, and Sinker was referring to when he said that good start with the Alberts and Higgins, throw the town of Canton in there too. Well, the town of Canton was thrown in there. Number 4, Keno Apothecary says, wouldn't it be appropriate to bring them in for the civil rights violation because it would be part of her defense by showing that they did such a bad job investigating and that they were biased? She couldn't have been the person liable to the O'Keeffes. Oh, that's a good point.
That's the argument. That's the argument that the attorney was making, her attorney. But it would be a case of first impression for me.
What, bringing in all the police because you're saying, I think, if I heard you correctly when we talked about this before, you're saying that the events of the evening or the night of January 29th, 2022, when John O'Keefe perished, however it happened, those events are separate from the later police investigation. I think that's what you're saying, but what about the gray area in between of the people that were inside of the Albert house on Fairview that night? You know, the Brian Higginses who owned the house, and Jen McCabe who was in there for a party, and the others. What? It's a sticky area, I would say.
Yeah, I mean, I like this guy's point. I just don't know if the civil rights violation is necessarily going to be consolidated with the civil action, but we'll see.
There's a saying that we learn in civil procedure, we don't want a trial within a trial. Is that what you're saying? That it would
Yeah,
involve
right.
a trial within a trial?
Right.
Yeah. On the other hand, the relevance of the issues in the civil rights claim and the claims against the Jen McCabes and Brian Alberts of the world who were inside of that house, they all stem from the series of events. They all stem from the nexus of facts that occurred that night. And so...
But that's not the only test, though. I mean, the nexus of facts is fine, but when it comes to people's claims, affirmative claims or causes of action, so you got Karen Reed, who is being sued for the wrongful death of John O'Keefe, and so if she wants to point the finger to somebody else did it, she can bring in, parties. If she is pointing the finger at the police that they did something to John O'Keefe, then that's something. But for her to raise her own civil rights that were violated in the process of prosecuting her criminally, that might be a separate issue.
Yeah.
That's what I'm saying.
I am looking forward to reading the briefs because Damon Salikson, the attorney, and I'm going to try and get him on the on panel here because I'm looking forward to reading his brief on this podcast. I'm looking forward to reading the prosecution's response, and I'm looking forward to reading the judge's response because I think it'll be you and I don't agree respectfully.
Well,
you and I don't agree, but I'm looking forward to reading what actually happens.
So this is a personal injury action. In other words, it's wrongful death.
Right.
So if you want to defendant wants to point the finger to other people, sure, go ahead. But now we're bringing in civil rights, which is a completely different type of action. So, but I like what this guy says. It kind of makes sense, but we'll just have to see what happens.
Yeah, it's what do you go with? The fact that they're two different causes of action, or the fact that there is such a thing as judicial economy, not trying multiple cases at the same time. I mean, not trying multiple cases in different courts at different times. Not that that's a concern at all to Massachusetts, but okay, Keno Apothecary, see what you started here.
That's a good comment because I see that. Yeah.
I like our commentators that make us think. This is what I mean at the end of every episode where I say, don't just call names, don't just tell us that we're idiots, don't just make us think like this guy here, Keno Apothecary. Thank you. Your turn.
Okay. So this is Mike OK8478. This case highlights a possible reason why news outlets stopped investigating and just parrot talking points provided by the authorities. If you investigate those in power, they will come after you, and they don't worry themselves about those pesky restrictions placed on them by the Constitution.
Yeah, good point. Pesky points raised in the Constitution, just minor little points. They just happen to be in the Constitution.
Well, that's the thing. I mean, reporters, they say, get your information from law enforcement authorities. But what if the law enforcement authorities are giving you botched information?
Or don't say anything. What if they stonewall you? Back when I was a reporter, people often would say, well, go talk to the district attorney. The district attorney wanted nothing to do with you. Get off of my lawn. Okay, number 2, Kirk 7143 says, at the last hearing, and we're talking about the Kearney case, at the last hearing, the defense requested an evidentiary hearing. No doubt Cosgrove will try kicking the can down the road for another 6 months, and that does appear to be what happened. We just talked about that quite a bit.
So this is 2 comments. CC and So-So, I like that name. Would love a look back at W. Bulger from a legal perspective. And then Joan C28, I'd love to hear about Whitey. I don't know much about that case.
How can you not? Well, all right, I've been in the greater Boston area for many years, so I would say, how can you not have heard about Whitey? But there are movies, there are books. This relates to, I had said that we will do an episode or at least a short on Whitey Bulger if enough people want us to. Of course, Hank Brennan, the special prosecutor in the Karen Reed case, defended Whitey. And so if we get enough comments, and we have gotten a fair number of people that are interested in the Whitey case, but if we get enough, and I don't know what enough is, I haven't quantified that yet, then yeah, we will look into it. Because Whitey was found out in your neck of the woods in California. He was in the Lamb. The FBI, the corrupt FBI, gave Whitey a heads up that he was about to be apprehended. So Whitey went on the Lamb, I think 16 or 18 years. I forget. I know I'll be corrected. I always am. But he was found out there in California right before everybody's eyes.
Yeah.
So your state harbored a criminal.
Oh, it's harbored many criminals.
Yeah, I'm not holding you personally responsible. So thank you for being with us. We already gave you our final thoughts. Oh my gosh, what should be our emoji this week for people that were with us the whole way through?
Boy, we talked about a school bus on the last episode.
All right, school bus. School bus.
Another school bus. Yeah.
Another school bus. That's fine. And one
or an ambulance.
Or an ambulance. School bus or an ambulance. Some kind of a vehicle, a public conveyance, I think is what they call them. Yolie, thank you. Good to see you again. Folks, be nice, be kind to everybody that you see, whether you see them at the mall, the grocery store, waiting in line, or at the registry of motor vehicles. Thank you.
Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.